these risks. Instead, if you go to slide number 8, why not have this structure where you have this operating business, this corporation, that is exposed to all of these risks from their employees and from their clients and whoever else, but this valuable asset is owned in a separate entity, in a sister entity. And we can license the use of that intellectual property, we can license the use of that equipment, or whatever the valuable asset happens to be, to the operating company. So now there is a lawsuit against this corporation. The lawsuit has nothing to do with this limited liability company that owns the valuable asset. It's completely separate entities from each other. Okay? I think that for any business that owns valuable assets, whether those assets are real estate or IP or equipment, this is the structure. Move the valuable assets out of the operating company. So if tomorrow there is a lawsuit against the operating company, the lawsuit has nothing to do with the valuable assets of this business. Okay? It's the common sense structure. It's not rocket science. But I see so many clients who do not have this and should have this. On slide number 9, kind of final, well, next to last point on entities. Let's say that we have a client who owns valuable assets through a corporation. Let's say it's Dr. Brown in apartment building number 1. And the question is, well, how do we protect this apartment building from a lawsuit against Dr. Brown? There are two ways of doing this. One is what you see on this slide, which is we take the corporate stock that Dr. Brown owns, and we transfer the ownership of the stock to a limited liability company. So once we do this, as you can see on this diagram, the asset that Dr. Brown now owns is a membership interest in this limited liability company. The LLC in turn owns the corporate stock, and the corporation in turn owns the underlying real estate. Okay? That's one way of doing this. There is another way of doing this that I think from a fraudulent transfer standpoint makes it a little bit more difficult for a creditor to challenge, and it's the following. What if we take this corporation that owns the real estate and we simply convert this corporation into a limited liability company? Okay? In practically every single state, you can take a corporation, file some paperwork with the Secretary of State. It's usually fairly simple and straightforward, 1 or 2 pages. And simply by operation of law, this corporation becomes a limited liability company. And all of the assets move out of the corporation into the LLC. All of the liabilities move out of the corporation and into the LLC. Very simply done. Once you convert, what is the entity that you have that owns that apartment building? Well, now it's a limited liability company. Now you have the charging order protection. For those of you who are tax buffs, you know that if you convert a corporation into an LLC, it may be treated as a liquidation of the corporation. And if it's treated as a liquidation of the corporation, what are the income tax consequences? Well, you will have taxes to pay. It can be a double tax if this is a C Corp on the built-in gain and the assets, or it can be a single level of tax if this is an S Corp. But with a corporation, if it has appreciated assets and it's liquidated, you will have a tax liability. So is there a way to do this and avoid a tax liability? There is. We can convert this corporation into an LLC, then file IRS Form 8832, check the box form, and elect to tax this limited liability company, this quote-unquote new one that we created, as a corporation. After we do that, if we need to, we can even make an S election. And what do we have now? Now we have an entity that is, for state law purposes, is a limited liability company. And if it's a limited liability company under state law, we have all the protections that we've talked about. We have the charging order protection. It's an LLC, and for charging order protection purposes, it don't matter how it's taxed. For income tax purposes, this LLC is taxed as a corporation. So you converted your existing corporation into an LLC taxed as a corporation. There are actually a couple of revenue rulings out there that tell us that this qualifies as an F reorganization, meaning there are no income tax consequences. And I believe in your outline you have the citations for those revenue rulings. One final point on entities before we move on to trusts, and that is, where do we want to register this limited liability company that we set up for the client, or this limited partnership that we set up for the client. And I hope by now you concluded that the corporation is not the way to go. As a matter of fact, if you do the choice of entity analysis, including the tax considerations and asset protection and economic flexibility, you inevitably come to the conclusion that really the only time you form a corporation is if you are going to go public tomorrow. And there are also certain states, like for example California, where certain professions can be practiced only through a corporation and not through a limited partnership and not through an LLC. But for all other purposes, there is really no reason to form a corporation. Your accountant tells you that, hey, from an income tax standpoint, I want you to transact your business through an S-Corp. Fine. Form an LLC, get the charging order protection of the LLC, and elect to tax this LLC as an S-Corp. But generally speaking, LLCs and limited partnerships are the way to go. They are much simpler, there is a lot more protection, and there's a general rule much better tax consequences. So the question is, we are setting up this LLC or this limited partnership. In which jurisdiction will we register this entity? Well, if our client, let's say, lives in Kansas, we'll set up a Kansas LLC. If our client has real estate in Texas, we'll set up a Texas LLC. Is that always the proper answer? No, it is not. If the real estate is in Texas, do we want to form a Texas LLC? Well, Texas LLCs, so happens, are not cheap. Texas is not the cheapest state to do business in. It's actually, up there with California and New York as being fairly expensive. Kinds of taxes that Texas subjects LLCs to. So if the real estate is in Texas, do we have to have a Texas LLC? Well, it depends on the type of real estate. If the real estate is income producing, then yes, we have to use a Texas LLC, and our choices are fairly limited. But if the LLC, let's say, owns the client's personal residence, then this LLC can be formed in any jurisdiction in the world. There is no requirement to register in Texas because there is no business connection to Texas. This LLC is not transacting business in the state of Texas. So for example, for my clients who, let's say, live in California primarily, if the client simply wants to transfer his investment account or his bank account or even his residence to an LLC, I will never set up that LLC in the state of California. California is expensive, $800 a year to have a California LLC. Why would I want to do that if I can form an LLC in a state like, I don't know, Colorado or Florida, pay something like, around $100 a year to have this LLC and not have to register it with the state of California. So simply to save money for the client, we will oftentimes go to a different state. There are other more substantive advantages, but they're fairly limited. For example, if you want to have a series LLC, there are only a few states where that is available. So if you want a series LLC, you have to go to Delaware, to Nevada, to Illinois. Certain states like Delaware and Nevada make it more difficult for a creditor to pierce the corporate veil of an entity. So if that's important to us, maybe I will set up the entity in one of those states. If the client wants privacy, and sometimes it is important, especially, let's say, for celebrity type clients. If the client wants privacy, there is really only one jurisdiction in the entire world where you can get complete privacy. And I mean in the entire world, even if you take into account all of these exotic tax havens that most people have never heard of before. And that one jurisdiction is Delaware. Okay? In Delaware, you can set up a limited liability company, and you do not have to disclose the identity of the manager to the state of Delaware. The only person that Delaware will know about is the name of the attorney who organized the LLC. That is it. There is no other jurisdiction in the world where that is possible, okay? Making Delaware really a very non-transparent state in some respects. So for a client who wants complete privacy, they can form a Delaware LLC. It's only the attorney's name that's on the registration certificate. And then let's say they acquire ownership of real estate in the name of this LLC, and no individual name ever shows up anywhere. So if the client wants that privacy, if the client wants that secrecy, we have to go with the Delaware LLC. And actually, we have a way of making it work, even if that Delaware LLC will then have to be registered in your home